So it's 6:35, and so Chris, if you could get the recording started. Thank you. So welcome everyone. Thank you all for being here. I will call this regular meeting of our Town Plan and Zoning Commission to order. It is Monday, April 5th at about 6:35 p.m. My name is Rob Klee. I'm the chair of the Woodbridge Town Plan and Zoning Commission. Other members of the commission who are on with us tonight at the moment are Yoni Zamir, Andrew Skolnick, and Jeff Kennedy. Paul Schatz is unfortunately delayed in travel and may or may not be able to join us, or if he does join us, he will join us late. Larry Greenberg is also joining us late, but as always, anyone who is missing portions will be sure to review things via video before we meet again and have our deliberations, and we will make sure we have all of that on the record as well. Chris Sullivan, thank you again for all of your support and help. I see we have Betsy Yagla as well to help with the WebEx and logistics, because as has been the case all year, we're operating remotely under the auspices of the governor's executive orders to prevent the spread of coronavirus. So we thank everyone who's participating in advance for your patience with the technology. And I ask you, if you haven't done so already, to mute your computer audio now. And thank you to, I believe, attorneys Hollister and attorney Herbst, who are joining us on the main stage, which is something we discussed last time. And I think the attorneys worked that all out to have you available during at least a representative from all different groups during anyone's presentation. So that's how we're going to go forward with today. So today we're going to continue our public hearing on the 2 Orchard Road application. We're going to continue that and finish that public hearing tonight. So the public hearing record for written communication is actually now closed. So as a reminder, everyone listening, our TPZ will base our decision on all the documents that are properly in the record. And I want to thank all the members of the public who have sent emails and letters and everything that have come in to Chris Sullivan. All that now is formally submitted, and the time for doing so is now complete. And all those documents, I believe, are posted on our TPC website. So thank you, Chris, and your team for having everything posted as well. So as I said earlier, this is going to be the last session of our public hearing. No testimony will be allowed after this evening either. As we announced on March 18th, we expect that's going to take us for the next 3.5 hours to have this final session. So I do ask that all the participants keep that in mind and try to be efficient and respectful of others, and try not to be repetitive or read letters or documents into the record that are already in the record. As a reminder to everyone, as always, as I've been doing consistently throughout, you cannot have direct communications with individual TPC members. That is not permitted at any time. This is an obligation that actually continues after the close of our public hearing portion when we move into the deliberation phase. So a little bit about the logistics around that. Our TPZ will have 65 days to conduct our deliberations and render our decision. So all deliberations will be conducted at meetings that will be open to the public. Although the public, the applicants, Attorney Herbst, and everyone else will be muted. This will just be a time for the TPZ. Comments and our communications in any form will not be allowed from the public, the applicants, or Attorney Herbst. There will be no deliberations tonight. We're just going to get through and close the public hearing. That's our goal for this evening. And then the TPZ will have the time over the next month to digest all this information that is materials that have been submitted. And we will begin our deliberations at our next regular meeting, which is on May 3rd. And I see, Larry, you have joined us. Thank you for joining us. And I also, while I have you, Larry, in this sort of upfront material, I was going to ask, did you watch the video of our March 18th meeting?
I watched it on YouTube.
Excellent. Thank you very much for doing all of it.
Every minute.
Thank you, Larry. Appreciate it. Okay, so there will be no deliberations tonight. We'll be deliberating at our next regular meeting, which is May 3rd. During tonight's public meeting on the 2 Orchard Road application, We're going to proceed in the following order. We'll start with the TPZ's consultant, Mr. Chalder. Then we'll go into public comment. So the public who are out there, be prepared for public comment after that. Then Attorney Herbst will go, and then we'll close with our 2 Orchard Road applicants. They will have the final word before we close the hearing. And our TPZ members, feel free to ask questions at any point when you feel inspired to do so. Then just for a larger scheduling note, this is our normal meeting. We do have a few business items on our agenda, which we will need to deal with tonight, including the turf field at Amity High School, but we're going to do that after we close the 2 Orchard Road public hearing. With that, I think we'll get started with Mr. Chalder.
Chris, can you allow me to share my screen?
Great, and as you're doing that, Chris, I'll ask, I'm going to go on mute. Larry, if you could go on mute too, and I think we'll all be muted.
Good evening, Mr. Chairman, members of the commission. I put together a presentation tonight to summarize information for the commission as we close out the public hearing and head towards deliberations overall. Things I want to talk about tonight as part of my presentation is the proposed regulation before the commission. The element of that revolves around the affordability plan, the plan of conservation and development, which is also one of the applications before the commission, possible framework for the commission to consider as we move through the deliberative process, and then a summary at the end. So in terms of the regulation, I think one of the things I've tried to stress for the commission's benefit throughout the process is that zoning can be an effective tool for guiding change, and zoning regulations can balance housing, community, and the environment. But the way the application has been presented to the commission, the balance that the commission may be seeking does not need to be achieved by allowing multifamily development in all residential zones, allowing multifamily development by a zoning permit alone, regulating multifamily development by building coverage alone, replacing zoning regulations with the health code, and ignoring statutory protections for public water supply watersheds. Communities throughout Connecticut, and really across the nation, generally regulate multifamily development by a density regulation. Connecticut General Statutes 8-2 authorizes the regulation of density of population. And Connecticut General Statutes 8-2G specifies an exemption from density limits for multifamily housing. So the regulation of multifamily housing by density regulation is fairly common in really all 169 municipalities in the state, and all of their diversity and all of the elements that they think are important are reflected partly through this type of situation. Communities have the authority under Connecticut General Statute 124, or Chapter 124, excuse me, that is the zoning section of the statutes, to zone their community in accordance with the comprehensive plan and the plan of conservation and development. Communities generally guide multifamily development to what they consider to be the most appropriate places of the community: town centers, transit-oriented sites, areas supported by soil types, terrain, and infrastructure capacity, where they believe that such housing will strengthen their community while addressing the important needs of their community. Communities generally establish a vision for how their community will be configured and show in the plan of conservation and development the most desirable use of land in the municipality. And it's really hard to explain this when there are 169 municipalities in the state of Connecticut. But I think if we take a look at the municipalities which the applicants have held out as being communities which could be examples for Woodbridge, I think there are some patterns which I want to bring to the Commission's attention. Do these communities allow multifamily residential development in all residential zones? And the answer is no, they do not. They have multifamily zones, they have special permits in residential zones and other things, but they do not allow multifamily development in all of the residential zones. Do they allow multifamily developments in public water supply watersheds? No, the areas where they allow multifamily housing are in other areas of the community. There's 2 possible exceptions. There's a small corner of New Haven over by the Woodbridge border that is a residential district and a public water supply watershed. And you could conclude that they allow by variance multifamily development in that small portion of New Haven. And also in Hamden, Quinnipiac University, some of their dorms are in a public water supply watershed. Do these communities regulate multifamily development by building coverage alone? And again, across the board, the answer is no, they do not. Do they regulate multifamily development by delegating to the health code? No, they do not. Do these communities regulate multifamily development by density regulation? The answer is yes, they do. I wanted to bring that to the commission's attention. So these communities also do not allow multifamily development with a zoning permit, except in some unique circumstances and situations. Generally speaking, they do not, but some may. But that's because the development is subject to one or more of the following. It's in a multifamily zone, and so multifamily might be permitted in that scenario with a zoning permit. It's served by public sewer and or public water. It's subject to density limits about the number of units. It's subject to design guidelines in terms of how the development will be configured. It's when they're encouraging the reuse of existing buildings, such as mill buildings in a downtown area. When it's in conformance with a previously approved master plan for the site, the preliminary approvals were done at a global level with the commission. Somebody might now be applying for individual buildings or construction, and on occasion that can happen through a zoning permit, but also when it's not in a public water supply watershed. Even New Haven doesn't allow multifamily development everywhere. New Haven has been held out as a community that the commission could look at. They do not allow multifamily development everywhere. They focus their multifamily development in and near the downtown on this map. These are the orange areas, which are the RM1 and the RM2 districts. They do not allow multifamily development in the single family districts except by a variance process. Then you have to claim hardship to basically confiscate the use of the property. They do not regulate multifamily development by building coverage alone. And they don't rely on building coverage alone, but they do use a density regulation to regulate multifamily development. I wanted to bring to your attention the presentation by the applicants at the March 18th meeting suggested that some of the reports that I had put in the record for the commission back in February were significantly outdated, perhaps because of their date. I'm not quite sure. But contact was made with DEP to ask whether or not these publications were still valid, and the response from them is that they are. These reports and recommendations are still relevant and valid for the commission and for their consideration. So I wanted to bring to the commission's attention again the recommendations from the Blue Ribbon Commission on Housing report. And this is a report to the committee at the legislative level, appointed by the legislature, working on housing related issues. The question was, what is the appropriate density for housing in different areas? And this is their recommendation. And actually, Woodbridge appears to have followed this, that in a public water supply watershed, 1 unit for 2 acres of land exclusive of wetland was their recommendation. I think there's also a challenge with regard to the public water supply watershed, in that the applicants have not really addressed the situation, how Section 8-3I of the Connecticut General Statutes will work on a zoning permit. Commission may recall that this section of the statute says that in a public water supply watershed, notification is required to the Department of Public Health and to the Regional Water Authority for any application to the commission. There's another part which says that if the application is for a zoning permit and the ZEO, the zoning official in charge, can conclude that the development will not adversely affect the watershed, then no notice is required. I think the challenge that we have in this situation for the commission to consider is that this is not just a notification requirement. It's not just about putting an envelope in the mail with a stamp on it. This requirement is meant to give these agencies the opportunity to comment back as to how this development may affect the public water supply watershed. And the real challenge that we have in this scenario with the zoning permit is if the comments come back with recommendations for impervious coverage, reduced density, modified design parameters. How does a zoning official deal with those when the zoning permit is a yes/no decision? So we have a real challenge with regard to this particular issue. It does appear from some of the information submitted by the applicants that we may have made some progress with regard to the issue of impervious coverage. They recognize that that is a standard which the commission can or perhaps should establish. We've also made notations that identify the need for screening of parking and refuse in other areas as part of their application. I think, again, that could be important consideration for the commission. But there's some issues still to be resolved in the proposed regulation. First of which, the way the language is written on rounding, it sounds as if anything above 0.5 gets rounded up. But what they don't talk about is what happens below 0.5, and it hints at the possibility that their approach may be that that gets rounded down. And I think the language needs to be modified here, that if there's any fractional remainder, even such as 1.1, that gets rounded up to the next higher whole number in terms of the provision of affordable units. There's no requirement that the location of the units be specified. There's a possibility that the affordable units could be moved around within the development, which makes it very difficult to enforce and manage. There's no clear requirement that the affordable units be built and occupied so that the development always complies. There have been some situations in other communities where the affordable units were left to the end and not always built. I think the issue of the building exterior and comparability is an important consideration for the commission. Additional clarification about roof types and wall offsets, the level of finishes in the units. There is a requirement in Section 830G(k) of the statutes about the external appearance of a single-family residence, and these are things the commission may want to consider. The other provisions of the regulations the commission may want to consider as part of the deliberations are organizing the sections for clarity depending on the decisions that the commission is likely to make, adding some definitions or modifying some other definitions in the regulations, and modifying the purpose statement to reflect the purpose of the regulation rather than the purpose of this application to the commission. In addition, there's some other elements that the commission will need to keep track of as we move forward. The proposal is to modify table 3.1, which is the use table, to reflect the decision the commission makes on this in terms of opportunity housing, to delete table 3.2 with regard to minimum floor area requirements, and also to modify table 4.1, which has a limitation on the number of families per building. Next major thing I wanted to talk about is the affordability plan. And I think there's a couple of key issues in here. I think one of which is the number of affordable units. There are a couple of options or scenarios presented by the applicant, but the lowest threshold in there is 10% affordable units. So that would be 9 market rates units for every 1 affordable unit. So it's possible that the commission could in fact require a greater percentage of affordable units. Connecticut General Statute 8-2I calls for inclusionary zoning and allows the commission to promote these types of uses and activities. And that might be something the commission might want to consider. The affordability threshold is another consideration for the commission. The applicants have offered that the units would be, at least one of the units would be at 60% of area median income. And that's a lower threshold than the 80%, which is sometimes proposed. And I think the other issue the commission may want to talk about is the affordability term. The 40-year term is the minimum that the statutes provide or require. And those units can actually disappear at the end of 40 years. There's examples around the state of where units are coming off the Affordable Housing Appeals list. And the question is this going to place Woodbridge in a situation of continually trying to build affordable units rather than keeping the ones that we have? I think the affordability plan is not something that can be understated or underestimated. The affordability plan is an extremely important part of maintaining the affordability of a development that gets created with affordable units. I think the challenge that we have at the moment is that there's really no specification in terms of the affordability plan and what it should require and what it should include. I've seen examples around the state of affordability plans, which are really not consistent with state law and state requirements. There's no standards for qualified administrators. The language has considerable differences in terms of income eligibility and how that will be determined. There's no standards for the zoning official to approve or deny the affordability plan as part of a zoning permit application. There's no requirement for filing of a restrictive covenant in favor of the town so that these affordability restrictions don't disappear. And if the affordability plan isn't followed, those affordability units can disappear. And I think that's something which we should spend some time talking about as part of the deliberations process. In addition, I think the marketing plan is inconsistent with state requirements. There are requirements in the Department of Regulations of Connecticut state agencies require that populations most eligible be identified. There be specific marketing approaches to those populations. And actually in the regulation before the commission is a scenario or a situation that says if I try to rent the unit according to their marketing plan and over 60 days I haven't been able to rent that unit, then I can rent it to the next available person. And that's not an affordable unit anymore. And so I think this is a scenario that doesn't seem or seems inconsistent with the applicant's original stated intent that there is this demand. Yet we have language in the affordability plan that says if I can't rent it, I'll rent it to a market rate person. I don't think that that's consistent again with their policy. I want to talk a little bit about the plan of conservation and development. I think this is an important document for a community overall, but I think the amendments proposed by the applicants are not really ready for action at this time. The description for the categories which are on this map have been modified in significant ways that don't really reflect what the map is showing. So I think there needs to be a way to find consistency between what the POCD is supposed to be stating and what the text is stating. And then I think the commission would be in a position to find whether or not the application is in accordance and consistent with the plan of conservation and development. So I want to talk a little bit about a possible framework going forward. I recognize the commission has received hundreds of pages of material, emails, and other information. The information may appear overwhelming for you. And if, as we head towards possible decision on the application, I think having a framework will be helpful for the commission. The applicant has proposed a one-size-fits-all regulation for all residential zoning districts in Woodbridge. This doesn't reflect standard regulatory approaches to multifamily housing, including but not limited to maximum density, statutory requirements for protecting public water supply watersheds, and really the actual circumstances in Woodbridge. And the map, which has been prepared based on the commission's request at the last meeting, is an attempt to show the locations of the different zoning districts in Woodbridge and the locations that have public sewer or public water available, and also the locations that are in public water supply watersheds. The net effect of this analysis is that we end up with a framework about 9 or 10, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 different types of or flavors of zoning districts in town. Generally speaking, the T3 zones do have public water and sewer. The B zone does not at the present time, but public water and sewer are available or nearby. In the A zone, not in a public water supply watershed, we have different scenarios of whether or not public sewer, public water is available. And then we also have the watershed district overall. The chart is meant to show what the current regulations permit and what has been requested in the gold circle by the applicants, and other options that may be available to the commission in the gray circles. And as we start to think about single family, 2 units on a parcel, 3 units on a parcel, which meets the definition of multifamily, or 4 or more units on a parcel, different ways that the commission might approach these scenarios. So my hope is that with the commission, we can go through these in a methodical way to make sure the commission fully understands the application before you and how you might wish to approach this. Also prepared as part of this some case studies to identify some situations in each of these districts so the commission understands the scenarios or the implications of each of these. And we can talk about that as part of the deliberation process. It is possible that other regulation changes may need to be made as part of this process. What's required to obtain a zoning permit, density limitations in other districts or other regulations related to impervious coverage, et cetera. A septic management ordinance, these types of things, and we can talk about that as part of the deliberation process. So in summary, finding balance is the key. I think the important thing to recognize here is that the goal of providing for affordable housing is not intended by the legislature to allow every development at the cost of damaging natural resources. And sometimes a different type or less intensive use of the land is demanded. The regulations shall also be drafted consistent with soil types, terrain, and infrastructure capacity, and to facilitate the provision for appropriate infrastructure and protection of water supplies, et cetera. So again, I think the theme which I've tried to place before the commission since February is that zoning can be an effective tool for guiding change, and zoning regulations can balance housing, community, and the environment. And I look forward to working with the commission to help do that.
Thank you, Mr. Chalder, for that presentation. I guess I will start with our TPC members to see if you have any immediate questions or reactions for Mr. Chalder. So while you are all thinking about that, I do appreciate that framework that you've sort of built out on the sort of multiple, the kind of diversity of zones, situations that we have. And I think that looks like a sort of systematic way to really organize ourselves and with all the stuff that's sort of been brought to us. So that's, I think, going to be very helpful as we move forward. Also, thank you to Chris and team for creating that map that kind of maps out on a geographic sense some of these overlapping, where's watershed, where's sewer, where's public water areas. So again, appreciated. Commission members, any questions at this point in time? You don't have to ask them. We can move on to our public comment. You can digest a bit, and you are always welcome to ask questions at any point.
Mr. Chairman, I do have questions regarding the response that the applicant put in dated April 1st. Really going to whether or not Mr. Chalder has any response or rebuttal to some of the points that they made. And I have some specific spots, but I recognize that that's not exactly necessarily on point to exactly what he's reiterated in this presentation today, but certainly, I thought today's presentation was concise enough, but I would like to hear his response at some point. I guess, it can wait until, maybe it's better if we wait until get through some of the public comment.
That's fine. Do that. Mr. Chalder's not going anywhere. He's sorry.
Sorry.
All right. Anyone else? Jeff or Andrew or Larry? Jeff, I see your hand.
Yeah. Yes, Rob, I actually agree with how Yoni just presented that. I read the April 1st comments too, Mr. Chalder. Thank you for your comments. I read Yale's response, the applicant's response to Mr. Chalder's comments, and I will have some comments in connection with the comments that Yale made. So it's more for the applicant team than it would be for Mr. Chalder. Mr. Chalder, thank you for your helpful information. I appreciate it very much.
Great. Thank you, Jeff. Larry or Andrew?
Actually, could I ask one specific question just to clarify in this presentation just now, there was a discussion about something regarding approving by variance. And I didn't think I understood what that meant. It was towards the beginning.
It was. Mr. Chairman, may I respond? Yeah. So the situation in the city of New Haven is that they have two different classes of residential zoning districts. They have the RS districts, which are single family, RM districts, which are multifamily. The RS districts, RS1 and RS2, do not allow for multifamily development in them. They are single family districts. They do have a scenario in their regulations where a property owner whose property value may have been adversely affected by the zoning regulations, rather than making a taking claim, would have the ability to apply to the commission. And there are hardship tests in the regulations that the commission, ZBA, would not grant permission for multifamily without a demonstration of hardship. So it's fairly unique that the authority is delegated to the ZBA in this scenario, but I also think it's an indication of how important New Haven treats their single family districts, that they don't allow multifamily within them without a variance.
Are there other municipalities along the lines of the list, or others that are a little bit more comparable to our demographics and layout? More importantly, our topographical and our sort of quasi-rural landscape across Connecticut that utilize that variance system, or is New Haven the one that sort of? I mean, New Haven is, it's difficult to compare New Haven and Woodbridge, so I'm just curious.
Yep. I struggled, Yanni, to try to find communities in Connecticut like Woodbridge that do things that the applicant has suggested or proposed. I think the issue of regulating multifamily development through a variance process is very unique. If I had a pie chart, there'd be a sliver, and New Haven is one. I did look at other urban municipalities. I looked at Stamford, which the applicant had offered. I also looked at the Hartford regulations to see what they do. And again, single family districts are single family in those types of scenarios. And then multifamily is allowed in multifamily districts. But I didn't do a cross Connecticut example of Woodbridge to compare.
Anything else, Yoni?
Not this time. Thank you.
Great. Andrew or Larry, anything before we go to public comment? No, nothing from Andrew, Larry, and from you?
No.
And I'm going to take that as a no from Larry as well. Okay. So thank you, Mr. Chalder. Hold on tight and stay put. We're now going to shift to our public comment portion, and it looks like we have Betsy Yagla potentially for assistance. Before we get there, I'd like to remind folks that this is actually one of the main purposes of our public hearing is to listen to comments from the public. So each of you will have up to 3 minutes for your brief statements to be entered on the record. I'll be keeping track on my phone. I will try to politely let you know if your 3 minutes are up and ask you to wrap up. So beware that I will be interrupting you at some point. As we've done before, if there are folks who haven't had a chance to speak yet throughout this it's a couple of months now that we've been having our public hearings. If you haven't had a chance to go yet, we'd love to hear from you first, if at all possible. So kind of hold back a little, lower your hand if you haven't gone yet. Remember, though, this is public comment, but the TPZ members or the applicants or Mr. Chalder, no one's actually going to be answering the questions that you're raising or the comment. We're just receiving information, which we are thankful for. It will be in the public record, of course, but we are not having a conversation or responding to questions from you. So as always, remember, off the record communications with anyone on the TPZ is not prohibited, and try to keep your comments focused on the subject matter that we've been covering over the course of this public hearing. So Betsy, that was my attempt to get folks to hopefully raise their hands. Do we see anyone who has a hand raised
I do not. So if folks are interested in participating, if you're on a computer screen, there should be a small icon of a hand in the lower right-hand corner of your screen. If you're on a cell phone, it's probably one of the small circular buttons near the bottom of your screen. It should look like a hand.
And hopefully is there any way to know to make sure that it's working, that it's enabled? I want to, just a question.
Oh, there we go. We've got somebody here. Mr. Brantz, you've been unmuted. Please go ahead.
I was just checking to see if volunteering to see if it works, and it does. That's all. I'm not ready to speak yet. Thank you.
Appreciate the testing of the hand raising. Again, any members of the public who would like to give public comment, that was your opportunity to raise your hand.
All right. Nicole Donzello, you've been unmuted. Please go ahead.
Hi, good evening, everyone. I guess I'll go first. I would like to make the comment, and I'd like to remind the commission, I'm sure you're aware, that the statutory requirements that we have been discussing this evening as well throughout this entire process do require the 10% affordable housing in every municipality. And we have not hit that deadline yet. And I would like the commission to notice that we do have until next year, July of 2022, to come up with an affordable housing plan. An affordable housing plan does not limit us to only multifamily homes, but rather it could also be single family homes as well. And that our town may just have the potential of adhering to these statutory requirements, i.e. the 10%, by not changing our zoning regulations. And I think it's a little too early for us to make a decision as to whether or not any zoning regulation should be changed without looking at what we have available to us now to be able to satisfy the statute. Now, as everyone is aware, we have, the town has formed a committee in which members of Woodbridge, residents rather, have been asked to serve to come up with the affordable housing plan. And I think that, in my opinion, that we need to wait for that process, that we need to, which takes into consideration not only the residents of Woodbridge, but also taking into consideration the needs around us in our geographic area before any decision is made to change zoning. Because it is ultimately, and this is discussed in the statute, up to the residents of Woodbridge to make this determination, no one else. So I would ask the committee, or the commission rather, to deny this application based on that. In addition, excuse me, I apologize, I have a cold. I would also like the commission to note that I do realize that the applicant, after reviewing all these hearings, has been utilizing phrases such as Woodbridge is practicing segregation, making accusations of racism. I think those are completely inappropriate and completely unfounded. As a resident, I do not appreciate those types of terms being used to characterize our town. And I don't think that the commission should be feel like they're backed into a corner and have to vote yes to this application. I would ask the commission to wait for, again, as I indicated, the committee to work with the commission to determine whether or not zoning needs to be changed after we look at the areas that are presently zoned that could accommodate the 10% mandate, and ask that this application is denied based on that. Thank you.
Great. Thank you very much, Ms. Donzello. If you could mute yourself and lower your hand, that would be appreciated. So I will ask again for members of the public, if you would raise your hand if you would like to join us for your public comment.
We've Got Lou Rotolo. You've been unmuted. Please go ahead.
Good evening, and thank you for the opportunity to speak. So the Open Communities Alliance claims that Woodbridge needs to plan for their fair share of 1,842 affordable units over the next 20 years. I realize that that's not what's required by 830G, but being a numbers person, it drives me to try to understand, where did this come from? And how is this determined? So after some searching, I found a lengthy study on the OCA website that determined affordable housing needs to be built in most of the towns throughout Connecticut, not only Woodbridge, totaling approximately 138,000 units. The South Central region, of which Woodbridge is part, has a requirement of 26,000 units. And this was stated to be a minimal need, as it only addresses the state's most economically challenged residents. How does this make sense? Constructing 108,000 units throughout Connecticut in the next 20 years will increase the current housing stock by 9%. There's no demand for this additional housing. A study performed by UConn projects the population of Connecticut to grow by a mere 50,000 people over the next 20 years. That's a need of about 20,000 units. What will happen with the 118,000 empty units once the residents relocate to these new apartments? The 26,000 units required in the South Central region is more than 50% of the current total housing in New Haven alone, where these financially burdened people most likely reside. This plan will move the people into the surrounding suburbs and leave half of the New Haven's homes vacant. New Haven and the other inner cities, which are affected by the same math, will become blighted. The homes will become worthless. Additionally, how do these affordable units address the stated problem? The state's definition of affordable housing is that which is affordable to those earning 60% or less of the state median income. The number of required units in the OCA study is specifically for those people earning only 30% of the median income or less. They still couldn't afford to live in these new units without assistance, as I'm sure they are receiving now. What's the real purpose of this proposal? How does building more apartments change the current situation? It appears the goal of this effort is not to alleviate anyone's financial burden, but rather to diversify the suburbs at the expense of blighting the inner cities, stressing the infrastructure, lowering property values, and raising taxes for all involved. The current proposal for 1,800 would, if the town is determined not to be compliant with the state statutes for affordable housing, which is 10% of the total units, then a careful plan should be formulated involving the residents and town officials to meet those requirements with minimal impact on our town's character and our resources. And the final plan should be approved by the referendum. I suggest or recommend that the current proposal be rejected. And I thank you again for this time.
Thank you very much, Mr. Rotolo, for your comments. So if you don't mind lowering your hand, if you could, be appreciated. I will again ask our members of the public if anyone has an interest in offering their comments, please do raise your virtual hand.
Mrs. Donzello, you've been unmuted again.
I'm sorry, I forgot to make another point based on what Mr. Chalder, I hope I'm pronouncing your name correctly, mentioned. And I believe one of the commission members asked this as well. If we look at areas in Connecticut that are similarly, I don't remember the phrase that was used, but towns that are similar to Woodbridge, I would ask the commission to look at Salisbury. Upon doing research on this issue myself, I have noticed that when this statute was passed, the governor at the time was looking at Salisbury, which is, for those of you who don't know, is in the Litchfield County, a very rural area, and looked at Salisbury as the gold standard, for lack of a better phrase. Salisbury is a rural area. It's an area very similar to ours, and the individuals in Salisbury created a affordable housing plan that, again, did not rely upon all multifamily houses. In fact, they were able to comply with it and were able to add many single family affordable homes. And I believe that anybody, when we come up with this plan, which again, I still stick to my main point that we should not rush into creating our plan. We still have plenty of time to do that. This application is just an application to build a multifamily in an area that is not zoned for it. I think that's the only issue that should be looked at this point. That being said, looking forward, of course, we all want to comply with the affordable homes mandate. So I would ask anybody interested in creating this affordable housing plan, myself included, to look at Salisbury for some guidance. This is new for everyone. There's going to be a lot of interpretation as to how we can adhere to the standards as mandated in the statute. So I would encourage everybody to do that. In addition, one final point, anyone who has either developed in the affordable housing market, has worked with any individuals who benefit from the affordable housing market, know that the best way to rise yourself out of a poverty level is to allow an opportunity. I mean, sure, we need rentals, right? But is to afford individuals the opportunity to own single family homes. You're able to build credit in that regard and things of that issue. So again, as I said previously, this may be an issue that we may be able to address with zoning the way it is currently. So I do not feel that we should be rushing into this because of the comments being made by the applicant about our town. And I think that we should just take our time, and we have time until July to create an affordable housing plan that's good for our town and the community and our geographical area as a whole. Thank you.
Thank you again. If you could lower your hand and mute. I'll ask again, anyone who hasn't gone yet, anyone who hasn't spoken yet, I know we have a few attendees on. Hopefully they're able to unmute. It looks like we've done that experiment and people can find that raise hand button. Okay, I'll give one more ask for those who may be just searching for that raise hand button. There you go. I knew when I get that near final go.
Mr. Hubbard, you've been unmuted. Go ahead, please.
Since I've spoken before, I just wanted to give others a chance. I do appreciate all of the due diligence of the TPZ committee, of the Mr. Chalder as well, and I see that there was a lengthy letter written by the applicants in response to a lot of the things that have come up. And I think again, I agree with the young lady who spoke a few moments ago. I think that this language of our town not being a warm and welcoming town to people is very false, and I think that people that sort of language is not necessary, and I agree with you. I like the concept of our town being able to the members of our town being able to all come together and to come up with a plan ourselves, as opposed to taking a plan that's pre-printed for us, which doesn't really seem to have our best interest in mind and at heart. And I do, again, want to express my gratitude to everybody for their diligence on this subject, and again, just ask the TPZ members to consider this very strongly, as it has a very deep impact on our town, contrary to what the applicants say. And as written, it can leave a lot of loopholes for some things that we may not really want to do in our town, like adding, namely, as Mr. Chalder pointed out, we don't want to allow our density to be controlled by the health department, because if we take that out of the way by expanding the access to public water and sewer, then all of a sudden we don't have control over it, and it's strictly determined by both, and that's not a good way to plan our town's destiny. So I think that again, want to reiterate my support that the TPZ members reject this proposal as written, and use some of the all of the information garnered in this public hearing, together with members of the community to come up with a plan that actually works for us and that would be fair to everybody involved. Thank you for your time and for your diligence in this matter and for all of the many late nights that everybody here has spent. Take care.
Thank you, Mr. Hubbard. And if you could lower your hand. So again, anyone out there who hasn't spoken yet, who has spoken before, but not tonight. Want to make sure this is our last part of the public comments. So I want to be deliberate here and make sure if there is anyone in our attendees who would like to raise their hand. Mr. Hubbard, you did just go, but you can, Betsy, you can unmute him too.
Go ahead.
There was one thing I just wanted to toss out there. The number of homes in Woodbridge, if I'm not terribly mistaken, is somewhere around the 3,200 number. And we are looking at the possibility, or the what's being asked of us is to add 1,842 more units. So we're looking at somebody who's trying, or for some reason, we're trying to be pushed to add 50% more housing units to this town. And I think that we need to be careful about how we come up with these numbers and how much we actually should be required to take as our true fair share. All right, thank you very much, and good night.
Thank you, Mr. Hubbard. Anyone else from the public who'd like to offer their 3 minutes? All right, I'll go once, I'll go twice. Any last, I see, I don't know why it always works, but it does. One more hand raised. Betsy, I'm going to keep doing that, Betsy, until we get everyone.
It works. Constance Royster, you've been unmuted. Please go ahead.
Constance, if you're talking, we can't hear you right now. Betsy, I'm not seeing a little microphone icon next to Constance. Is that an issue?
She's unmuted. Just muted her, unmuted again. Usually you see the green icon when someone's actually speaking, indicates that they're making noise.
Gotcha. Constance, if you're on a phone, if your phone is muted, maybe the system has unmuted you, but your phone is still on mute. Betsy or Chris, any ideas here?
No.
Seeing any microphone image at all next to her name. You know, normally it's either the red with a cross going through it that they're muted, or as Betsy said, there's green to show that the mic is open, and I'm not seeing any mic.
The green indicates that someone's actually making noise. So that's why we're not seeing anything, is because if there's an issue with her microphone where she may be speaking, but we're unable to hear her.
Yeah, Constance, I don't know if you can hear us, but we're not hearing you.
She's still able to email in any comments, or did that deadline pass?
No, that closed this morning.
Okay.
Maybe if Constance wants to try to. Oh, sometimes I've had where one person ends up calling someone else to then hopefully get them through. Yeah. So Constance, maybe we'll go to Mr. I keep seeing another name flashed up, but then it went away again.
There he is.
Oh. If you can grab Mr. Zerina.
Shoot. Mr. Zerina, you've been unmuted.
Oh, thank you very much. Can you hear me?
Yes.
Yes, we can.
I just want to address the commissioner and Mary Ann Dubuque and everyone involved. Thank you so much for taking my comments. I wanted to make a comment for a very long time, but I was never really able to connect very well. So I want to make a point that the zoning that has been established all over our state was originally put forth to allow orderly development and not to establish exclusionary zoning like the applicants have stated. And what we're trying to do is with zoning is to, as you have heard from Mr. Chalders, and we're trying to have the lowest possible threat to the environment. And this is basically due to our U.S. Constitution and protection of our watershed areas in Connecticut, which is practically every area in our state. And it's not to promote exclusionary zoning. That's very critical. My question I have, and I don't expect an answer now, obviously, you just told us that. Why are we focusing on rentals instead of home ownership? Of course, we're in the middle of a zoning application for affordable housing, but there are no metrics proving that affordable housing can actually benefit the affected populations. And in fact, there are metrics that support, that actually prove that affordable housing actually does not improve the wealth or income of these voucher holders and these vulnerable populations. The best way for families to pass on wealth to future generations is home ownership. Therefore, our applicants are really disingenuous in their purported claims of social justice and using them, basically using these voucher holders and everyone as pawns on a chess. It's very unethical. Really disagree with their tactics, and I just think it's very unfair to us in Woodbridge. And on top of it, the applicant's cookie cutter approach to zoning, a la State Senator Anwar and his desegregate Connecticut opponents, that would really disembowel Connecticut Statute 8-2, the Zoning Enabling Act, which would have many unintended consequences in our town. Unfortunately, what the thrust of this initiative and this application is to urbanize our towns. And we don't have the infrastructure to do that. And if we change the infrastructure, as Mr. Yang, one of the LSO interns suggested, that would be that would be just not a very responsible thing or financially viable. And just forget about the mill rates. They would just it would be a blank check to just fiscal imprudence. I just don't support that sort of thing. What they should do with multi-dwelling housing and affordable housing is put it where mass transit is and put it where the jobs are. And isn't that really what we should be aiming for? More jobs, more opportunities, so we can diversify and have a more, I guess, pluralistic society in Woodbridge, if that is what our applicants are really promoting. That's the best way to do it.
I'd ask you to wrap up if you could.
Yes, don't urbanize our towns. And thank you so much for hearing my comments.
Great. Thank you, Mr. Serena.
Thank you, Mr.
It looks like, let's see, we have Drew Bear. Let's try that one, and then we'll try again with Constance.
Okay. Oh, we just lost Drew. So I will try Constance. Go ahead, please, if you can try again. Constance? Okay. So Drew withdrew his hand, as did Constance.
Well, Constance, just raise your hand again.
You're still unmuted, Constance, if you can try again.
So how about this? Constance, if you can try to log back in and out, we may move to Mr. Herbst and then offer that one last chance for Ms. Royster if it's a problem of what she's using to try to get into WebEx. I don't know, Attorney Dubuque, is that okay? Okay, sounds good. So Constance, maybe try logging out, logging back in, and we'll give you one more try. I don't see any other hands from other members of the public, so we will just limit that to our last chance for instance, Royster to give a try. Alrighty, I think we should keep going. No need for a break right now, if everyone's okay with that. Because next up on our agenda would be Attorney Herbst. So Attorney Herbst, if you are ready to go, the floor is yours.
Thank you, Mr. Chairman. Did you want to take a break first? Did you need a break?
No, I think we're
okay.
Good. Eventually there'll be a plate of food that will magically appear in front of me and I may start eating, but that's...
I'm jealous. Good evening, Mr. Chairman and members of the commission. For the record, my name is Timothy Herbst. I'm an attorney in Orange, Connecticut, appearing, as you know, on behalf of approximately a dozen concerned residents who live in the vicinity of the property that has been identified for this application. I want to begin my comments by using a word that's been used frequently to describe the town of Woodbridge, and that word has been exclusion. And I'm going to use the word exclusion in the context of this application because I think there has been exclusion of thought and exclusion of varying points of view that have offered what I believe to be very relevant and constructive criticism and alternatives that, quite frankly, should be explored and embraced by not only the commission and the town, but also the applicant for that matter. Much of what your consultant said this evening mirrors much of what we were going to say on the record. I don't want to be repetitive, but I do want to reinforce the fact that I looked at the letter that was sent by Open Communities Alliance on April 1st, 2021. And, I looked through it and I read through it several times. And I just want to point out I'm going to point out certain comments that were made in the letter. And I'm going to, if permissible, respond to that and provide some greater context. On page 12 of the letter, Open Communities Alliance says, quote, during the March 18 hearing, Mr. Chalder presented a disjointed assortment of proposals for potential changes to our application that are not based on any valid organizing, planning principle or rationale, period, close quote. In point of fact, what Mr. Chalder has done this evening and what he did in the submission that was provided to both the applicant and to us is that he went through the communities that the applicants referenced to determine what standards those communities had in relation to what's being proposed for the town of Woodbridge. And what we have learned from Mr. Chalder's analysis, and I want to reemphasize this point because it's significant, multifamily development is not allowed in every single residential zone as is being proposed here in Woodbridge. And as we have maintained from the beginning of this process, under 8-2, you have every right to determine what specific zones you would like to see multi-family development. You are under no statutory obligation to put multifamily development in every residential zone in your town. In none of the communities that the applicant cited was multifamily development regulated solely by building coverage alone. In all of the communities cited by the applicant, multifamily development regulations were not delegated to the health code. Each of these communities had their own standards in the zoning code. And in all of the communities that were brought up by the applicant that Mr. Chalder analyzed thereafter, every community is allowed and does regulate multi-unit development by density. Why? Because 8-2 says you can. And that is the statutory framework that you follow to determine how you plan and zone your community. So, in point of fact, what Mr. Chalder did was he took the communities that were cited by the applicant and in a very well done job, systemically went through and compared the proposed regulation to those communities. Mr. Chalder is on record as saying that the proposed multi-unit density under this regulation in the town of Woodbridge would be greater than the multi-unit density in the city of New Haven. And that analysis is important for your consideration when you consider this application and the long-term town-wide impact that it's going to have. We also believe very strongly that the application is woefully inadequate with respect to how you not only implement, but for lack of a better term, police your affordability plan. Because if you are going to develop a regulation that allows for greater opportunity for affordable housing, you want to make sure that those affordable units are counted towards your goal. And you want to make sure that you are meeting certain benchmarks and meeting certain goals. Not having that type of a standard in your regulation, you're almost working against yourself as a municipality. You can't have it both ways. You can't tell a community they need to get to a 10% goal and then not provide ways that the town can track and enforce how they're getting to that 10% goal. So I absolutely agree with Mr. Chalder that there should be a standard codified in the regulation, whether it be a restrictive covenant or a process for how those units will be identified on a go-forward basis. Because what you are considering now is not only about what we're doing here tonight, but you're developing a regulation, presumably that's going to have a long-term impact. So there needs to be greater control over how it is going to be policed. I concur, and we concur with the recommendations in your planning report concerning the affordability standards, income eligibility, price determinations, median income requirements. That needs to be flushed out by this commission. We agree that the regulation needs to be beefed up to include those standards to help guide the commission. And I will also tell you that I am deeply concerned by the lack of standards for how a zoning official can approve or deny the zoning permit. There should be, if you're going to determine, first of all, I don't think it should be done as of right over the counter. I think these proposals should be reviewed by the Planning and Zoning Commission. I believe they should have special permit approval standards or site plan standards that are clearly codified in the regulation. But if the commission elects to allow this to be done administratively, I believe that the commission, acting in its legislative capacity, has to develop a regulation that provides objective, uniform guidance to your zoning officials, present and future, for how and when that permit is issued, because it is putting the zoning enforcement officer in a position of having to call audibles. And that's not how zoning should work. There should be a clear standard for your zoning enforcement officer to follow. With respect to the reliance on the regulations of other entities that would have input on this regulation, I think you're going down a very dangerous path in doing that. Because if you determine that the zoning enforcement officer is going to administratively issue these permits, you're getting into a very dangerous situation when a zoning enforcement officer who is responsible for the administration of a zoning code is interpreting the regulations of other administrative agencies. And I think what is being proposed is almost inviting that. And when you do that, you run into trouble, because there is case law in this state that essentially says that when acting in an administrative capacity, administrative agencies need to stay in their lane. You cannot enforce the regulations of another entity other than the regulations that you're charged with enforcing. There's appellate case law on that. So I think that is another significant problem with the proposal as has been submitted by the applicants. The other thing that I will note is that during the course of this hearing, our consultant, Brian Miller, I thought did a very good job of introducing the guidebook that was promulgated in 2020 by the Connecticut Department of Housing. And I know you, Chairman Klee, asked extensively questions about that guidebook and how it should be utilized by local towns and cities in developing affordable housing regulations. If you look at that very carefully, many affordable housing proponents were actively involved in developing that framework. It brought all stakeholders from all sides of the issue together to develop something that was a standard that would provide guidance to towns and cities across the state of Connecticut in how they should be developing plans. I will note that the applicants glossed over that plan, didn't respond to our introduction of it into the record, and wouldn't even acknowledge recommendations that were made in it that would help Woodbridge achieve the results that we all agree are needed. And let me just say this, I've been on record from the beginning of this process saying absolutely something needs to be done. The regulations absolutely do need to be addressed, but the regulations absolutely do not need to be altered and changed in the way that the applicant is proposing. So I think that this commission can rely upon Mr. Chalder's planning report, which I thought was outstanding. I believe that this commission can rely upon that report in the context of also utilizing regulations that have been promulgated by the Connecticut Department of Housing, providing guidance to communities across the state of Connecticut. And I do believe that the Planning and Zoning Commission, through a deliberative, collaborative, non-exclusionary process, can come up with a regulation that makes sense for your community. Just want to also point out some of the language in the letter that I find really concerning from a planning standpoint. The applicants on page 13 say, quote, if adopted, Mr. Chalder's suggestions would produce a bloated, affordable housing regulation that would fail to serve its stated purpose. As we know from Woodbridge's own history, with its never used and functionally unusable affordable housing district regulation, affordable housing programs laden with restrictions can serve as a tool of exclusion. When reading Mr. Chalder's recommendations, think about how a developer might possibly try to comply with its rules and still make a profit, period, close quote. I have a couple problems with that statement. First, in fact, in the presentation you heard tonight from Mr. Chalder, he's actually making recommendations as to how you can increase affordability by doing it in a way that you determine is appropriate. And he has pointed out the deficiencies in the applicant's proposal in not providing enough affordable housing in the minimum requirements that he reviewed and went through during the course of his presentation tonight. The last part of that statement I have the biggest problem with, when it says, think about how a developer might possibly try to comply with its rules and still make a profit. Your charge under 8-2 and 8-23, I know of no statutory language that says that a planning and zoning commission has to consider a profit margin for a developer in developing regulations for your community. You are all civic volunteers, and you work for the taxpayers and citizens of the town of Woodbridge. You do not work for a developer determining their profit margin. So no regulation should be developed that considers that as a fundamental guiding principle. Also on page 13, quote, Mr. Chalder suggests a number of watered down versions of our proposal to allow multifamily units depending on the zone. As a starting point, there is no legitimate reason supportable within the record to differentiate among the zones in this way, period, close quote. I fundamentally disagree with that. And in point of fact, you have significant material in your record that allows you to consider different zones and where that multi-unit zoning should go. These conclusionary statements have no basis in fact, are not supported by any quantifiable data or anything that the applicants have put into the record to justify those types of conclusions. Page 15. Quote, Mr. Chalder's suggestion that the town ought to require deed restrictions in perpetuity would undermine this balance by making opportunity housing an infeasible investment for developers, period, close quote. Again, you are developing regulations for the benefit of your community in providing affordable housing for those that need it. You are not developing regulations to facilitate developers making a profit margin. That is not your charge. And for the applicant to suggest that with no statutory authority to support that, I find alarming. I think that these deed restrictions are absolutely necessary to make sure that the town is properly tracking and administering when and how you are reaching or coming towards reaching your 10% goal. You can't have it both ways. You can't come into a community and say you're exclusionary and then in the next breath say, oh, and by the way, we don't want you to track your progress. Can't have it both ways. What Mr. Chalder has proposed is absolutely necessary to allow your municipality to properly track if you're meeting your 10% threshold. Again, page 15, quote, first, developers and financiers are incentivized to build housing when there is an end date to deed restrictions. An end date creates residual value in a property, value that emerges when the restriction expires. Property owners, underwriters, and lenders can rely on this value when coming to terms in the financing process, period, close quote. Again, there is nothing that I can see in 8-2 or 8-23 or the Affordable Housing Guidebook promulgated by the Department of Housing for the state of Connecticut that says that a planning and zoning commission should consider these factors in developing a regulation. The factors that you consider are public health, safety, general welfare, district standards, how you want those districts to have standards for multi-unit development, density requirements, impervious surface requirements, all within your purview under the general statutes. Page 16 of the letter, quote, referring to Mr. Chalder, quote, he is wrong and woefully uninformed, period, close quote. First, I think your planner's very well informed, and that's why he provides consulting services to municipalities across the state of Connecticut. Goes on to state, quote, it is premature for the commission to adopt a maximum density regulation. In the future, if a clear need for density restrictions develops as the town builds new infrastructure, it can then consider limitations. At this current moment, however, limitations on density would only add to the list of requirements the town imposes on multifamily housing that it does not impose on single-family homes of similar size. Large urban cities in the state of Connecticut apply density regulations. Every town referenced by the applicant in trying to prove their point have density regulations and restrictions. So to say that this is premature, I wouldn't use the word premature. I would say that this is standard. It is normal. It is customary for a community, big or small, to have standards. The applicants keep referring to them as restrictions. That is not the word they should be using. These are standards. They are standards that should be applied in an objective manner for every applicant that comes before your board or goes into the zoning department for a zoning permit. So I cannot underscore or emphasize in the strongest words possible how if you were not to have a density regulation and or restriction in this regulation, and then you take the position, oh, well, we'll revisit it. Let's see how it works. And then we'll come back and we'll revisit it. That's essentially what they're saying. That is not proper planning. That's why we have planners that work on behalf of commissions. The Planning and Zoning Commission sets policy. They are the what? People like Mr. Miller and Mr. Chalder are the how. They have the professional acumen, credentials, expertise, and experience to tell you how to develop a regulation that addresses a concern or a vision for where you want to go as a community. So I cannot state in the strongest terms possible that much of the conclusionary statements contained in this letter of April 1st have no basis in the record, have no basis in fact, and I think provide a very misguided approach to how the town should approach its regulation and in developing any revisions to the POCD. I said from the onset of this process that we believe changes do need to be made. We believe that any change to a POCD should be commission-driven and not applicant-driven. We believe that if you're going to change your POCD, you follow the framework as articulated in Connecticut General Statutes 8-23, which calls for a collaborative process. It is not collaborative to tell a commission they don't know what they're doing. It is not collaborative to tell Mr. Chalder he doesn't know what he's doing. It is not collaborative to tell Mr. Miller he doesn't know what he's doing. And it is not collaborative to summarily dismiss altering points of view because you don't necessarily agree with them entirely. A collaborative process takes several points of view, and you work through those points of view. And then you develop a regulation that makes sense, that gets the town to where it needs to go. What the applicants are attempting to do is to take a square peg and attempt to put it through a round hole. They are taking a one-size-fits-all approach to this that is fundamentally wrong. This process needs to be collaborative, deliberative, thoughtful, thorough, and you are not required to make any type of knee-jerk decision. And this commission is not required to feel intimidated to respond quickly in developing a regulation. I said in one of my earlier presentations, when you start wrong, you end wrong. And this application is starting wrong. And I think this commission has gotten it right in how they've approached it, in hiring Mr. Chalder, in pointing out the fundamental deficiencies in this proposal. And the proof of that is how many of those deficiencies have not been directly answered. And that underscores where this regulation misses the mark on so many levels. You know, I will conclude by saying that I know that Mr. Brantz is on the call, Attorney Brantz, who I have tremendous personal and professional respect for. And I say that because 13 years ago, when I chaired a planning and zoning commission, it was Attorney Brantz who helped us revise comprehensively our entire zoning code. And in that zoning code, we had an affordable housing regulation. And that affordable housing regulation was thorough, deliberative, thoughtful, and collaborative. And that affordable housing regulation looked nothing like what's before you tonight. So I am asking this commission on behalf of my clients, on behalf of the town of Woodbridge, the citizens of the town of Woodbridge, and quite frankly, on behalf of the citizens of the state of Connecticut who are watching this very closely and counting on all of you to do the right thing, to summarily deny these applications, to get to the drawing board in a thoughtful yet expedited manner, to heed the recommendations of your planner, and to develop a regulation that does make sense, that does work, and that will move Woodbridge forward. With that, Mr. Chairman, I thank you. I thank the members of the commission for all your hard work and efforts, and your volunteerism and service to the people of Woodbridge. Thank you.
Great. Thank you, Attorney Herbst, for that presentation. Let me see if we have any questions specifically for Attorney Herbst from TPC members. I also want to see if I know. So let's see if there are any questions directly to Attorney Herbst, so we can pause. At the end, TPC members can ask questions of everyone as well. And then I know we want to also try to get Constance Royster the opportunity to give public comment if she managed to get the tech figured out. Which I see she has her hand raised. But Constance, you hold tight while I'm going to have our commission members. Yoni Zamir, did you have a question for Attorney Herbst?
Yes, I do. Thank you, Attorney Herbst. Appreciate your zealous advocacy on this complicated question, and I appreciate the experience that you're bringing to the table in your advocacy. I'd like to ask you about some referencing the applicant's April 1st letter, the 30-page or so letter that you read from, and then cross-referencing Mr. Chalder's has made several presentations, most recently tonight. And one of the things that Mr. Chalder focuses on is the issue of the density requirement. And I'm wondering if you might respond on page, it's in the document itself, it's labeled as page 16, but if you have it open, in Microsoft Word or in in the PDF form, I think it shows up actually as page 19, because I think there's some, the table of contents isn't numbered. So it's labeled, page 16. Are you on that page?
I am, sir.
Yeah, so you see how it says under Affordability Plan, bolded, B, establish more stringent bulk regulations for multifamily developments. In the second paragraph, if you just take a second to look at that second paragraph, you see what I'm talking about. Mr. Chalder previously stated density. Okay. Are you familiar with the statewide POCD?
Yes. Yeah.
And so do you have a comment or a take on this line? I mean, this whole paragraph, right? This whole paragraph seems to be saying that, not seems to be, but it says that Connecticut rejected the concept of using density requirements in applications as a way of protecting watershed, right? We've all said repeatedly here that protecting our watershed is of the utmost importance. And so it points out that the statewide POCD, that's 2013-2018, requires and rather encourages towns to adopt impervious surface restrictions. Now, I'll tell you that I haven't looked at our POCD to cross-reference to see if our Woodbridge one, our current one from 2015, has anything about impervious surface restrictions. It may. I'm just wondering if you have a reaction to to that whole paragraph, right?
Well, I don't necessarily agree with the characterization, because if you read the paragraph carefully, at the end of the paragraph, they're talking about reducing the impact of development on a per capita basis. So when you're doing that, you're spreading it out. So you're looking at the proposal in the context of its impact on Woodbridge. What they're kind of doing is they're splitting the baby with the bathwater. They're looking at the impact on a per capita basis and how the state plan of conservation and development not only impacts Woodbridge, but the entire state. So I do think that it doesn't analyze it the way it should. And as I should point out along those lines, Mr. Chalder made very clear in his presentation that there still is an issue with 8-3I and how they consider dealing with that. And I think that's another flaw in the proposal. I think that if you're considering adopting this or considering coming up with your own plan, which is what I support, I think that you want to take a look as a commission at 8-3I and determine how you can come up with something in your local regulation that addresses the watershed issue.
So, I mean, I read the last sentence of that paragraph to be stating that the statewide POCD discourages municipalities from using density requirements to protect watersheds because the evidence they suggest shows that higher density housing actually reduces the impact of the environment by minimizing the amount of impervious surface per capita per person. And you're saying that that's a short-sighted way of looking at it. Am I characterizing you correctly?
I am, because I think you need to look at all of it, not just part of it.
All of it meaning the whole.
Well, what they're saying is it's not an optimal method to protect watersheds. So they're not summarily dismissing it. I think you have to look at both, though, in the context of a local regulation. Again, the one size fit all, clearly when you adopt a POCD, you go through that process I talked about, the commission process, the legislative process. If the legislative body makes changes, it kicks back to you. You have to consider the state POCD, your current POCD, your comprehensive plan, and then you take it through that process. So I think when you develop your own regulation, which is what I hope you'll do, I think you need to look at the density requirements and also the impervious requirements and or restrictions.
Sure. Mr. Chairman, I appreciate that, sir. Thank you, Attorney Herbst. Mr. Chairman, I'd certainly yield to other members, but I wouldn't mind to hear Mr. Chalder's response take on that specific point if he was listening. But if you would rather do that another time, I would be fine with that too.
No, you're welcome to ask Mr. Chalder, and I might only add to this conversation a question, or at least a view that I might have, and maybe both Mr. Chalder and Attorney Herbst could react to this, that couldn't you read the statewide plan of conservation development as generally trying to encourage development in places that are already developed? And that is, from the statewide sort of broader perspective, that they're looking for places where you already have development instead of adding more impervious surface in places that you don't have development. Is that another sort of fair reading of a statewide view? Is a question for Attorney Herbst first, I guess, and then Mr. Chalder can chime in.
I'd like to hear the planner's reaction, if I may.
Sure.
I'll opine on that.
I think there's 6 fundamental statewide growth management goals, and the protection of public water supply watersheds is one of those 6. Of course, one of the 6 is also the improvement and enhancement of housing opportunities throughout the state. So the state plan did change in the 2013 to 2018 version. The language that had existed in prior plans about watershed density was replaced with the language with regard to impervious coverage. I think all of these are important issues. And they kind of deal with different perspectives on the same issue. One issue is coverage, which is the actual drainage and runoff from a piece of property because of rainfall and what happens with that. And I think the secondary issue is what happens under the surface with density and number of housing units per acre. If you have a certain impact, though, the description of that impact is, well, if we put more people there, the impact per person is less, is really kind of a false argument, because the issue is it's the impact, the size of the impact, and what the impact is. And putting more people on it just reduces the number, but it doesn't really change the impact. So I think you have to remember that I think those statements are being characterized in a way to make that statement. And I think that's an important consideration.
Appreciate that, Mr. Chalder. Yoni, did you have further, or Attorney Herbst?
No, it sounded like very similar to what Attorney Herbst pretty much just said. I don't know if there's anything he has to add to that.
I concur with that.
Mm-hmm. But did anybody answer your question? I don't hear. I mean, I haven't heard Attorney Chalder or Mr. Chalder. Would you use it? I mean, what Commissioner Chairman Klee is suggesting, right, is the theme that we've been kind of exploring already now for at least the last meeting, if not the last two, which is that there are zones in our town that exist in which, and as you've suggested, right, that there are existing zones in our town for which this affordable housing, multifamily housing development is appropriate. And the applicant's response in summarily sort of like dismissing your points, Mr. Chalder, is, they try to take them apart one by one. I felt like this was one of the points that you've repeatedly made, right, regarding the density question. If you end up with a site somewhere in our A zone, where some developer buys a property and we find that they are attempting to create the development of a property that will house something along the lines of, more than 8 units, or the potential for, the number of people who will regularly inhabit the space will be exceeding what we currently see as our average in Woodbridge. And the strains that are put on there, right, they seem to be rejecting your points that we ought to craft something that limits it and controls it further. And the thrust of their argument is, if I read their letter correctly and I read their application correctly, is that you're raising concerns that are all rebuttable, right? So what I'm trying to do is I'm trying to hear whether or not we can, who's dismantling whose arguments. I mean, that's kind of how I'm listening to it right now.
Well, I mean, I think everybody, the applicant is making arguments to the commission to promote their application, to place it in the most favorable light, to create observations about other arguments which they may not agree with, and I get that. I think the issue before the commission that I think I've tried to stress in my work for you is part of this.
Just lost you.
I apologize. I was gesturing with my hands and hit my touchpad, and of course turned off my mic. So I apologize for that. The point that I wanted to make is I think what I've tried to strive information to put before the commission is to seek a balance in that situation between housing, between the environment, between the community, and to figure out what works best for Woodbridge in this scenario. There are fundamental differences between many different parts of town. Their ability, given soil types, terrain, and infrastructure capacity to address these kinds of issues, to juggle the various elements of the state plan. There are 6 responsible growth principles, and 2 of them directly apply, and certainly in the watershed areas, which is the protection of public water supply watersheds, And that's really kind of the origin or genesis, I think, Johnny, of the 10% rule. But there's also the density rule in terms of the number of housing units that go on it. If we were to build a high rise of multiple stories with a very small footprint, you might argue and say, well, that doesn't have very much impact per capita. And on a coverage basis, it would not. On a density basis, it would. And so I think you need to recognize that there's multiple facets to the argument, and all of those should be part of, I think, of your consideration.
Yeah, I mean, you know, with all due respect, I think using that as an example, I think muddies the issue, and I think it frightens people because nobody is proposing
No, they're not.
building a multi-family, multi-story large apartment building. It's the same problem that we had with the golf course. Is people were worried that we were going to find ourselves with a strip mall with bordellos and liquor stores. It was never going to happen. It was never conceptualized. Nobody has proposed it. No developers come along. So is it your position that page 16, that paragraph, that it's not a mischaracterization of the statewide POCD, but just that it's presenting it in a very narrow way? And what I'm hearing you say is that there are more than just density factors that need to be considered. That's what
I think the commission should take a comprehensive view of all parts of this application.
Yeah.
Yes. And I think this, if I may, Yanni, for a moment, I think in my initial response at the very beginning, I was trying to touch on Rob's question, which was the issue about the responsible growth principles of the state of Connecticut. And that, yes, I think they are trying to reduce the density or intensity in sensitive areas, such as public water supply watersheds. And they are trying to support regional centers, which to promote economic development in these areas and strong communities, et cetera. So there are elements of state growth guidance which I think are applicable in this situation. So I did try to.
I just, Chairman Clea, if I could just add to that, I would just like to, for purposes of the record, call to the attention of the commission, page 24 of the State Plan of Conservation and Development. Quote, minimize the impacts of development on drinking water sources by utilizing development forms and densities that limit impervious surface coverage to 10% of the overall area to be developed, and which preserves the amount of land in a natural or undisturbed state, period, close quote. And that's page 24, the State Plan of Conservation and Development.
Thank you, Attorney Herbst. I do see that we have joining us on his very long adventure here, Commissioner Schatz has joined us. So good to see you, Paul.
For the record, sir, I've been participating via telephone for the last 40 minutes, but so thank you for welcoming me. I appreciate it and my adventure.
It's good to have you back, safe and sound, Paul. So other commission members with questions for Attorney Herbst?
I got a couple.
Great. Jeff, go right ahead.
Sure. This is for Attorney Herbst, and it might also go to Mr. Chalder, but I have to say, I read the April 1st document from OCA and the applicant, and this is going back to something we've already discussed, but I was very surprised that about their treatment of Mr. Chalder's comments on the affordability plan. And we've already talked about that a little bit, but that really surprised me. It seems to me that the affordability plan is in fact a central feature of opportunity housing, that it's how you would make a plan to in fact develop units where you would have market rate multifamily housing rentals balance out the non-market pricing that we're looking, that they would be looking to support. Their treatment in that paragraph almost seemed like they were attacking their own proposal a little bit. And the specific question I have for you, Attorney Herbst, is that, I agree that it's vague and impractical, but they put a comment in there, and they can comment on themselves. But their language is standard template that has been widely has been adopted statewide. Is that true? Like their exact language?
I read that, Commissioner, and I do not think it is widely adopted. And the proof that it's not widely adopted, as I said in my comments, is that when Mr. Chalder, who I think did an outstanding job of analyzing the towns that the applicant brought up at a previous meeting and going through the proposed regulation in the context of those other towns, both towns and large cities, what we saw through his analysis was that essentially what they're proposing is not standard. I'd like them to codify where it is. They make the statement, throughout this, I'll call it letter. Throughout this letter, they make a lot of footnotes that have actual citations. So they will say something and then they'll cite to a source. If you look at that paragraph under the affordability plan, they're making broad generalizations. They're making conclusionary statements. They're making conclusionary statements about Mr. Chalder's expertise, which I take exception with. They're making very broad and conclusionary statements about how this plan's a best practice, that it's a standard template, and they're not providing you with any type of citation or source to justify that conclusionary statement. And I think this letter's loaded with a lot of that. And again, if the applicants were truly motivated by the town of Woodbridge providing affordable housing, what I can't understand for the life of me is that you've got a very experienced planner. He's outstanding. I've worked with him before in a former life. Outstanding. He's giving what I believe to be very constructive recommendations for how a regulation can be adopted and not be exclusionary and not be restrictive. He just wants to put clearly articulable standards in the reg to help the town reach an affordable goal. And to just summarily, reject a lot of his recommendations and then question his professional acumen, I just think it's reckless and irresponsible. And I have to tell you something. You know the old saying, sometimes you get more bees with honey? I think if there was some kind of a halfway here where they embrace at least some of what he's saying and come in with a modified proposal or show a willingness to modify the regulation to get to a place where the commission and where open housing advocates and where residents can come to some level of consensus. That's inclusionary. What they're proposing is exclusionary in the sense that by saying to you, we don't need planning and zoning commission review, there's no special permit standards, there's no site plan review, we're going to put it in every residential district in the town of Woodbridge, as of right, over the counter, by the ZEO, with no standards as to how the ZEO should process those applications. That's not inclusionary. That's one way of thinking, and it's not addressing a lot of the very valid and bona fide concerns that have been put on the table regarding the regulation as is. So to long and short of it, I really disagree with the conclusionary statements offered in 3. And I think they need to quantify what they're saying. Show me how it's standard. Show me how it's a standard template. Show me where it's been referred to as a best practice. Just show me the source.
Thank you. No, thank you. Look, I think the affordability plan is an essential accountability aspect of their language that they have in the planning and zoning language they're asking us to adopt. And I appreciate your comments. It sort of surprised me, given how they are presenting their views to us, that they so easily kind of brush that aside and set it aside, because it seems more like a marketing plan that a developer of a multifamily housing would want to have, that's apart from trying to help the other side supporting homes for below or non-market or marketing areas that we would want to support to help more lower income households. I
You know,
appreciate your comment.
the other thing, Commissioner, just to add to that, and I touched on this in my initial presentation, but if you go to the end of page 16, it says it is premature for the commission to adopt a maximum density regulation. In the future, if a clear need for density restrictions develops as the town builds new infrastructure, it can then consider limitations. The question that I would raise by doing that is, what happens at that point if you've grown at such a pace that you can't consider limitations at that point? But let's say you go as they're proposing, no density restrictions, and they say, okay, well, you know, let's just revisit this and see where it takes us. That is very bad planning.
Okay, thank you. Appreciate it. Mr. Chalder, did you want to weigh in specifically any further on the affordability plan and its accountability?
No, I think my statements in terms of the concerns I have about its long-term effectiveness and the ability of the CEO to review it and determine whether or not it's acceptable. I think I've stated that multiple times.
Yes, you have. Thank you. Mr. Chairman, I yield back.
Great, thank you, Jeff. Other questions of Attorney Herbst from Larry or Andrew or Paul? I'm hearing none right now. Obviously, TPZ members, they're not going anywhere. We can still ask questions when we get to our last presentation. I'd like to now give one last try for Constance Royster to be unmuted to offer her 3 minutes of public comment. So Chris Sullivan, I know we lost Betsy, so can you try to unmute?
I just unmuted Connie and hopefully she can talk. Every time I go to unmute, the mic disappears. And
Yeah.
I don't know what's going on.
No, that happens. It only reappears when you're actually speaking, and it then becomes a little green icon. So unfortunately,
I mean, her hand's raised. There's an exclamation point.
Exclamation point is, yeah, it's a strange one. I don't know what that one means. I'm not a WebEx.
You know, when I hover over her microphone color, it's showing that I've unmuted her. I don't know what else we can do. Unless she wants to try to call in.
Yeah, there is the call-in option. So, Connie, it was on the agenda for the public hearing. I know that Paul Schatz managed to do it from his ride on the way back here. So it is doable. There's a call-in number and an event number for this and the passcode. So if you want to give that a try, and then raise your hand. Can they raise their hand?
You know, I can't see a name when they call in. So if she just wants to email me, because I can see emails, and let me know that she's called in, then I can try it that way. And so Connie, my email is very simple. It's been said many times. ksullivan@woodbridgect.org.
Okay. So Connie, we'll give you one last try by any means necessary to get your public comment in before we end this evening. So hopefully you'll do that via calling. How about we take a 5-minute break now to allow Chris, you don't get a break. You get to bring on our last set of presenters, the 2 Orchard Road applicants. We'll reconvene at 8:35. That sound good? Okay, we'll see you all in 5 minutes. Thank you, everyone.